Hi, everyone. We're going to get started in a couple minutes. We'll just give everyone a couple minutes to join in. All right, it's 6:05, so we're going to go ahead and get started. Good evening, everyone, and welcome to Hanging Out Your Shingle and Common Mistakes Young Solos Make. This event is co-hosted by the MSBA Young Lawyers Section Education Committee and Civil Justice, Inc. My name is Laytom Dewson, and I'm a co-chair of the MSBA Young Lawyers Section Education Committee, and I'm also on the board of directors for Civil Justice, Inc. And I, along with my co-chair, Rima Kakani, want to thank you for attending this evening's event. So we're going to get started, and we're going to do a quick poll. So if you could take 30 seconds to answer the poll questions, and then we will share the results. All righty. Okay, so the first question was, what type of law do you currently practice? And it looks like the majority are solos, and then government and firm, and in-house and other. And then question 2, what stage of your legal career are you currently in? It looks like the majority are 5+ years of practice, followed by under 2 years of practice. And question 3, what brought you to today's event? Looks like the majority are just curious about solo practice. So thanks for taking that poll. All right. So we are going to get started by having Sarah Coffey Frush, who is the Executive Director of Civil Justice, Inc., She's going to tell us a little bit more about civil justice. So Sarah, take it away, please.
Thank you. Hi, good evening, everybody. My name is Sarah Coffey Fresh. I'm the Executive Director of Civil Justice. Thanks so much for joining us tonight. A little bit about myself. I am a 1999 graduate of Georgetown University, and I am a 2004 grad of University of Maryland School of Law. My background is that I came from Maryland Legal Aid and Maryland Legal Aid subsidiary, the Maryland Center for Legal Assistance. Probably the most notable part of my work was piloting and expanding their statewide network of self-help centers. By the time I left, after about 9 years, there were 6 offices serving about 80,000 Marylanders, unrepresented Marylanders statewide. And so kind of this taught me about the huge crush of Marylanders who are unable to find effective legal assistance. And that's really what led me to civil justice, is I hope that our solo and small firm attorneys around the state can really have both thriving practices, but also help increase access to justice. So for those of you who don't know, Civil Justice is a nonprofit, and our mission is to support a statewide network of solo and small firm attorneys who share really a common commitment to increasing access to justice for Marylanders of limited financial means. Traditionally, our CJ network of attorneys has been best known for their really groundbreaking consumer protection work, as well as their foreclosure defense advocacy. Many of our members, Jane Santoni included, who is the speaker tonight, are nationally recognized litigators for their work to challenge and eliminate actions of predatory businesses who really seek to take advantage of low and moderate income consumers. And while we're really best known for that consumer protection work and the foreclosure advocacy, we have a statewide network of a little over 100 attorneys, and they come from a wide range of practice areas, including family law, bankruptcy, employment law, and general civil litigation. What I would like to say is that for newer admittees to the bar who become CJ members, they have access to this really thriving community of really seasoned litigators who lend their thoughts and time and talent to kind of informally mentoring newer members to the bar. But members also benefit from our trainings, our referrals, and some stipend-based practice opportunities that we're launching in the coming months. And this is really a reflection of how we want to support solos and small firms who want to make a meaningful impact on narrowing the access to justice gap. If you have any questions about CJ, don't hesitate to be in touch with me. I am readily available, and I hope tonight's presentation is just really helpful for everyone. Thank you.
Okay, thank you, Sarah. And now I just want to briefly introduce our speakers for tonight. We are very lucky to have them. So first we have Jessica Boltz, who is Assistant Bar Counsel with the Attorney Grievance Commission of Maryland. She graduated from the University of Maryland School of Law, and since then has worked for the AGC, starting out as a law clerk, then as a staff attorney, and now as Assistant Bar Counsel. So we are very lucky to have her here today. Next, we have Jane Santoni, who is a partner with Santoni, Bacci, and Ortega. Jane also graduated from the University of Maryland School of Law and has years of experience with personal injury cases, consumer protection matters, landlord-tenant violations, debt collection, bail bond violations, negligence, slip and falls. She does it all. Next, we have Divya Patar. Divya graduated from the University of Baltimore School of Law. Following her graduation, she worked, I believe, with Wise Law for about 5 years. And for the last 3 years, has been the founder and principal of her own law firm, Diva Law, where she handles personal injury and other civil litigation cases. And finally, we have Jay Stafford, who graduated from the University of Virginia School of Law. Following his graduation, he clerked at the Court of Appeals and worked for a couple of different firms, including DLA Piper, before opening his own firm, which he has been the founder of for the last 5 years, I believe. And he represents physicians, dentists, nurses, and other professionals facing disciplinary actions by their licensing boards, as well as other individuals and businesses in employment law issues such as discrimination and non-compete litigation. So thank you, Jay, for being here. And with that, let's get started with our panel.
All right, so we are going to start with a practical topic, opening your practice. So we want to know what sort of things a young attorney should be looking for, what factors when deciding to open their own practice. And we'll start with Jane.
Hey, well, thanks everybody. It's really good to be here. Just to give a real brief introduction about how I ended up here. When I graduated from University of Maryland back in '86, I originally worked for the governor of the state at the time, realized politics was not in my future. Went to work for a judge. I clerked for a little while. Then I went to work for an insurance company as defense counsel. I did that for 14 years. And then we all got laid off in 2002. That was a great gig for me because when I had my kids, they let me go part-time, got to try a lot of cases, raise my children, and also, have benefits and the pleasure of a steady paycheck. At the same time, for me, it felt like it was starting to suck my soul out. And so when I ended up getting laid off, it was an opportunity. And I realized that the only people that were going to hire me were other insurance defense firms. And while that's perfectly fine for some people, for me, the thought of a career of 25 years as a insurance defense lawyer, 25 years more after the first 14, I couldn't do it. So I started my own practice with a partner, and we were going to do plaintiff's personal injury work. And that we had no clients, we had no income, we had no benefits. It's not as if we left the firm with clients because our client was essentially the insurance company and all the insureds. So we kind of started from scratch, and people started coming into my firm who were getting ripped off financially, and it just made me incensed. And I felt like I had found my calling, that they needed help. And so I was really grateful to be able to start doing that work, and civil justice was invaluable. And I don't want to take up all the time talking about that. So that was sort of how I ended up where I am since 2002. And if you take a look at the first slide, the areas that you have to think about when deciding whether to open your own practice start with these things and more. And I think this is actually Diva's slide. So Diva, I don't know if you want to talk about this first, and then we can pick up on it from there.
Did you say this was my slide?
I think so. Yep.
I don't think so.
Oh, if it's not, then I will keep going.
Go ahead. It's all you.
Didn't want to step on anybody's shoes. So business structure, briefly, a business structure starts with, do you want to be a solo? Do you want to be a partnership? Do you want to be a firm? And we're going to talk about partnerships in a little bit, but who are you going to be? Once you've decided that question, the next one is, are you going to be an LLC, an LLP, or something else? The first firm I had was a limited liability partnership. My current firm is a limited liability corporation. I believe there is not that much difference, But when you're deciding to what kind of business structure you want, what we did was we sought out an attorney who specializes in that type of work. So I would recommend you talk to somebody, and actually civil justice has some people who are fabulous to guide you through. Steve Ball helped us with that. Regarding office logistics, where are, how are you going to run your office? Are you going to start out by yourself? Are you going to have employees? Are you going to have a remote office? Are you going to have a physical space? I found when we started out in my partner's basement. That was before the days of remote, and we ultimately decided to move to an office. Nowadays, with COVID, working remotely is much more important and feasible. But with office logistics, you also need to think about where are you getting your supplies? How are you getting your computers? How are you funding your equipment? What equipment do you need? Again, all of that I think is much more simple nowadays because the ability, the rise of the computers, the remote work, the internet. So I think that streamlines office logistics tremendously. And again, I think the best way to deal with that is to work with somebody who has already done it, a mentor. And again, I'll say civil justice or MSBA has some guidance on that. Employees, we started out with no employees. Then we decided to hire a secretary. We got the cheapest secretary we could find. And then we realized that she was committing malpractice by giving legal advice to people over the phone. Don't recommend that. So we ended up having to let her go and paying for a good assistant. And so that will be, I believe, your biggest cost. And you do not want to scrimp on that. My experience has been that sometimes you need to hire the person before you really think you can afford them, because you almost can't afford not to have help if your practice requires it. I know of some solos who do everything themselves, and that is not beyond the realm of possibility. But what you want to think about is, am I spending time doing things that I could be making more money if I didn't have to do them? And so that's where you want to think about that. Financial metrics, we'll get into that, I believe, a little further in the slide. The way I look at that is, what do you need to survive? You need to come up with a budget and then figure out how you're going to make the money you're going to make. We'll talk about that more. Mentorship, just don't go it alone. We'll talk about that a little bit more. And then malpractice insurance. I believe it's a huge mistake to operate without it. I know lawyers who do, but I believe I would never do it, and I would never co-counsel with somebody who doesn't have malpractice insurance. So that's it for me.
All right, Jay, what do you have to add about opening a practice?
Yeah, I think everything Jane mentioned, but I think it's worth spending some time on that question of what type of practice do you want to have, like in terms of like what's your practice area. And I really think a lot of times, sometimes people can overlook that. I think it's so important as a solo that you're in a practice area that you literally could wake up and do and not get paid $1 and still be motivated to do it. Because as a solo, as a solo, it's all you, right? You're the marketer, and the first, like there's someone who said, look, the first sort of sale has to be yourself, right? You have to believe in whatever it is you're doing. And so I think that the first order of business is you really have to buy in terms of the practice area that you're going to pursue. And for me, I mean, I recommend that, I think the best way to go is a niche practice where you're maybe 1 or 2 practice areas at most two. And that's, how you, I think, build a successful practice, a more efficient practice, because if you don't have to worry about multiple practice areas, you can really go deep into that practice area and really people will know when to call you. So I think spending time on what type of practice do I want to have in terms of practice area, I think is a key question.
Divya, what do you think are some key factors when opening a practice?
So quickly, my background, I graduated from University of Baltimore, fell in love with the Mount Vernon neighborhood. So for me, when I was looking actually I ended up, Wise Law is in Mount Vernon. And then when I was looking for office space to start my own office, I wanted to only be in Mount Vernon. I live there. I have all of my friends there. The bars and restaurants, although during COVID, are no longer the fun places that they used to be. But that was one of the things for me when I was opening up a shop, because I have a physical brick and mortar office, so I call it my shop. I found a little place in Mount Vernon that was an office building shared with multiple different businesses. So I think another thing to think about more about in the lines of what Jay said is what type of practice do you want to have? You also want to think logistically, what type of practice do you want to have? I do personal injury litigation because that's all I've ever done. That's what I have experience in. I stay in my lane. I don't take cases that I don't know what I would do with. I started my shops 3 years ago. Before that, I've always worked for solos. The last place that I worked at, I helped grow that firm. It was a pretty new firm. We, I think, had 3 employees. It was 3 of us all together. And then by the time I left, it was 11 of us. So I learned a lot about running a small practice. When I was there, I wore many hats. Like I would deal with the web designer, I would deal with ordering furniture, I would deal with IT, I managed staff. So I saw a lot of things that worked well. I saw a lot of things that could be improved. So I decided one day, why don't I just go do the same thing for myself? I would spend nights and weekends, I was spending long hours, and why not do that for myself? So I think another thing to consider when opening up your own practice is your work ethic. I don't think it's not for the weak. It can be if you want, but I'm the first one in the office most days. I'm the last one to leave the office. I'm there on weekends. So you definitely need a good work ethic. I was fortunate enough, my ex-boss was supportive of this decision. So I was able to take a lot of the cases that I already was handling with me. He didn't want to litigate, so all the cases that were in litigation, he kind of let me take, and we had an agreement about the fee split. So that helped financially with the starting of the firm. As for business structure, I made an LLC, filed with the State Department of Assessment and Taxation. That's all I knew because that's the bosses that I worked for, that's what they had. I understand that's also one of the easier corporations to form. I'm just a single member LLC, no partners. As far as office logistics, because I have a brick and mortar shop, there's a lot to think about. How much rent can you afford? The computers that you're going to get, the printers, the copier. I have most of my correspondence with insurance companies is via fax. So I have one of those old-timey big copier fax machine combinations. So I rent that. You have to talk to Comcast, BG&E, build a website, your case management system. For employees, I started out with 1 employee. I now have 3 employees. You have to think about payroll, health insurance, parking. We're in the city, so I give parking to my employees. Any other benefits that you want to discuss with them. For attorneys, you might have some sort of fee split agreement with them. For financial metrics, I guess you need to figure out what your overhead is, but then on top of that, whatever bills you have personally, like I have a mortgage, car payment. I don't have any kids that I have to pay for, so that's good. I was fortunate to be able to have health insurance otherwise, but these are things that you want to consider when you first make that decision, because you're kind of on your own when it comes to making your mortgage payments, making your car payments, making your student loan payments. Malpractice insurance, I 110% agree with Jane. Do not practice without malpractice insurance. I didn't know where to go, so I actually contacted one of the Bar Association sponsors, and they were able to broker I think it's one of the brokers that we have as a MSBA, and I know they also sponsor MAJ. So I went to them, and they helped me with malpractice. When I got another attorney that worked with me, went through them for her malpractice as well. Mentorship, very important. Once again, this is where bar associations come into play. I would highly, obviously you're all MSBA members, I would also suggest finding out bar associations that specialty bar associations for your practice area. For plaintiffs' work, we have the Maryland Association for Justice. There's a lot of solo practitioners of all experiences, all age groups. I actually have a smaller group of solos through MAJ, and we kind of just have like an informal roundtable. We keep in touch with each other, talk about employee issues, talk about cases, talk about how are you doing e-signatures during COVID, various different aspects that might come up that you wouldn't even think about, and a lot of times don't want to necessarily, post on the listserv that, hey, how do you do this? And then keep in touch with people that you've worked with before. So a lot of my practice area is referrals from other attorneys from other firms, and offices and lawyers that I worked for before send me cases. So just keep in touch with people that you've already known, that are already in your network.
Thanks, Divya. So Jay, I'm going to go back to you real quick. Since this is your slide and it talks about know your numbers. So you say you need a bookkeeper and QuickBooks. Tell us, for example, how'd you find your bookkeeper? Tell us about the line of credit, some of these things that you put on your slide.
Yeah, I think, as a solo, just any business, you're a business owner now. All right. So when you open the shop, you've got to make sure you've got money in the bank to pay bills. Okay. And so I tell people, look, you got to know your numbers, and you have to know what to do when you see the numbers. And so I've got a book I recommend that, because look, the bookkeeper, and, literally asked a friend of mine, like, hey, do you have a bookkeeper you use? He referred me, and it's been great. And, she every month goes in and reconciles the accounts, which from a personal standpoint, because you're a business owner, you absolutely have to do this, not just because of bar council, which, I know Jess is going to talk about that, but because look, if you need to go buy a home, the first thing they ask is, we need to see all your firm's bank records, financial statements for the past 3 years, whatever. Okay. And so you got to make sure all that stuff's good. But when the bookkeeper gives you the numbers, like the profit and loss statement, the balance sheet, all that stuff, well, you got to know what to do with it. I've got a book that I recommend, I think is very helpful. It's called Accounting for the Number Phobic. And it will tell you, it gives you some insight into what the numbers mean. All right. And so it helps you understand what you need to do once you see the numbers, and what actionable steps you can take to help the numbers get better. But you definitely need a bookkeeper. You definitely need to get your accounts. And a bookkeeper from the very beginning, I think, is helpful. You got to understand also, and this is where an accountant can come in, the taxes. All right. Depending on your structure, you very well, may not be getting W-2 income. You may be taking draws from the firm, and there's another world of tax implications associated with that, because the last thing you want is at the end of your first year to be surprised by the tax man, because that is a painful surprise. And then secondly, one thing I will say, if you haven't made the jump to a solo yet, if you're thinking about it, one of the things I think I strongly recommend is figure out, how long can you go working in your firm without taking an income? Like, do you have, because a lot of this is driven by what's your personal financial situation, right? What obligations do you have to the household, to yourself, whatever. Because the longer you can sort of buy yourself time to not have to take funds out of the firm, the more you can capitalize the firm. Meaning, look, if you can set aside a good amount of your income from maybe the first year of the firm opening and put it in a firm saving account where you can really capitalize the firm, make investments that you need to make, maybe hire that employee that Jane mentioned that you don't think you can afford, but you know you're going to need 3 or 5 months out, then that's what you want to do. Because right now, if you're still working a regular job, I mean, my recommendation to you is really try to play with your personal finances and see how strongly you can sort of lock down your expenses. So that way, when you step into the firm and you open it up, you can have enough space to go a few months, 6 months, 9 months without having to feel stressed about getting a lot of income from the firm. Because if you're starting from scratch, that's a very look, it's not easy. And the last thing you want to do is not give yourself enough time to be successful. So know your numbers personally, and it relates to the business, and make sure you get the support you need to make sure you are capturing those numbers and taking actionable steps once you get those numbers.
Hey, Tom, if I may add a little bit more for the know your numbers portion of it.
Sure.
If you want to do contingency fee cases, which is what I do, you
Yep.
can't start with $0. It takes money to make money in contingency fee cases. So all of the costs that go into litigating a case, I have to put up front. Expert witnesses can get pretty expensive. Depositions can get expensive. Any sort of court costs, private process server costs, all of that I front up front. So the bigger your cases, the bigger your case expenses are going to be. So just depending on what type of cases you want to handle, you definitely need to have some cash in your operating account.
Yeah. And do you work on a line of credit as well?
No,
Okay.
I'm wary of credit.
No, I understood. But one thing I will say is even if you don't use it, just not talking to you, David, but just everyone else listening. Look, I have a line of credit. I don't touch it, but it's there just in case. I recommend that if you can get a line of credit with your bank for your firm, get it. And, look, you can let it sit there and that's fine, but at least it's there if you absolutely have a situation where you need to touch it.
Yeah.
Yeah, it's an insurance policy. We have a line of credit, and you do not want to wait to ask for a line of credit until when you need a line of credit. You want to get it in advance.
Jane, I want to go back to you. You mentioned earlier a budget. So we're going to go to the slide about a budget. And if you could just talk about that, and we'll do kind of like a sample.
Sure. Well, everybody else talked about this a little bit, so I don't want to go over it too much again. But basically, what is my salary? That's talking about what I have personally. What are my needs and what are my other bills? What are my salary needs? Do I have a family member who's working who can help? Am I on my own? That type of thing. So you want to figure out realistically what salary are you going to need to survive. Malpractice insurance, you want to budget that. Supplies, office equipment, we talked about all of that because you're going to need to pay for the paper and the computers. And along with that, even though it's a little bit different, we hire the accountant, we hire the bookkeeper. I mean, I don't think, especially with taxes, I don't think lawyers, unless you're a tax lawyer, should be messing with your own taxes. And you don't want to put that in the wrong hands. So you need to hire a good accountant. Some of these things are just necessary. I'm sorry, can you go back to the other side? So in addition to that, rent, staff, we talked about that. And then Eva talked about advanced case costs. So all of those things go into the pot. Okay, and here's an example of how to get there. What do you need to make in order to, or how, if your goal, let's say, is $300,000 a year, then how do you get there? Now, if you're doing straight personal injury, that may mean you have to settle a certain number of cases at a certain average, amount per case. And in PI, you can have the really valuable case, and you can have the little cases, and you can go through dry periods, but it's still good to figure out your inventory. What do I need to bring in, and how much do I need to make off of each case to make this work? In the type of work that I do with the consumer protection, we work on fee shifting statutes. So that means we keep track of our time, and we get paid at the end if we win or we settle. Or if you're in the type of practice where you've got where you're billing your clients, you need to know, what do I need to bill? How many hours do I need to work? How many cases do I need to handle in order to make that goal that I've set for myself? And this slide talks about that. An hourly rate should be above your collection goal, because you're going to have some cases that are not going to turn out, at least in the consumer protection contingency world. Some are going to go south. Now, if you are paid by the hour for what you do, you're probably going to have a little less of that bad inventory, but even then, you're probably going to have to write things off. And your hourly rate, I've seen lawyers with like 1 year experience who want to bill at $500 an hour. You have to pick a realistic hourly rate. And I can only address that in fee shifting stands. We go by, the federal government has developed a what they see as reasonable in the federal rules, and so we use that and have increased it a bit. So you want to pick your cases that will produce your goal. If you say, well, my goal is I'm going to work 10 hours on a case and I'm going to make $5,000, but you have a case that's worth $200, we're filling whatever numbers. Well, that's not going to get you where you need to go. So you need to take a look at that. And for us in the fee shifting world, am I in a jurisdiction that's going to pay that hourly rate? Because some judges, when you say, at the end of a case, our time is $65,000, they won't bat an eye. Other judges think that you're not entitled to $5,000. I can't believe a lawyer would make that. So you've got to watch your jurisdiction. And then you need to file enough cases to keep it going. If you're on the plaintiff side, my experience has been, you're not taken seriously unless you're filing things. So you want to make sure you've got a steady stream of case filing. And then critically important, if you're billing hourly, whether that's contingency or upfront, you have got to have a really solid program to track that. We use the NEOS program. That's the software that my firm uses now, but there are lots of different ways that you can do that. And then you also want to keep a chart of your progress.
Okay, thank you, Jane. We are now going to move into marketing and how to find and get those clients. So Divya, if you can start us out, that would be great.
As I touched upon earlier, most of my clients come from word of mouth referrals from clients themselves and other attorneys. So I kind of developed this practice area where I did litigation for other solos that didn't want to go to court. So that's how I kind of started. And then I guess I started also getting cases from much larger firms where it was not worth it for them to go to court for the smaller cases. So I built my practice off of that little niche area. As far as website, letterhead, business cards, envelopes, I have a wonderful friend who's a graphic designer who designed all of that for me. And since then, I've actually passed her name on to some other solos that have also used her services. As for networking, bar associations, bar associations, bar associations. Unfortunately, we're not seeing each other in person right now, but that there's no better networking for me because I get my cases from other lawyers. So I'm going to network with other lawyers. My referrals, once again, will come from other lawyers. So it's beneficial to network through bar associations. I'm also pretty involved in my neighborhood. So I get referrals from various stores and neighbors and whatnot in the neighborhood. What else? I don't market via TV advertising, although I do know some people that refer me cases that do that, and they're wonderful at that.
Okay, thank you. Jay, I know you had some great points about knowing your ideal client, where to find them, and when to actually say no. So could you address that a little bit?
Yeah. Look, I'll tell you, this is sort of experience learned from mistakes here. And so, look, knowing your ideal client is half the battle. The other half is knowing where to find them, right? And so, you've really got to think about, okay, who do you want to work with? Who are good clients for you? And the answer isn't just a paying client, because I'm telling you, as somebody's told me a long time ago, not all money is good money. And, if you see the train wreck prospective client coming as a solo a mile away, and you've got to trust your gut not to get tempted. So, as you're thinking about building your firm, really think about who your ideal client is. Again, to the extent that you have deep experience in your practice area, you'll kind of know who your ideal client is. And then think about, well, look, how can I get in touch with that ideal client at a time when they are in a position to need my services? So, for a lot of folks that are consumer based, that may be in a situation, look, where you're relying heavily on Google ads or an internet strategy. If you've got deep ties in the community, that's great. But, look, you may have to explore that internet situation, because look, at the end of the day, a lot of consumer-based clients don't need a lawyer until they need one. And in the first place they look oftentimes is the internet. So it's something to keep in mind. And so like I said, as you're building your firm, you want to build around the ideal client so that everything on the website, your marketing materials, is all based on attracting that ideal client to your firm.
Okay. And then Jane, finally, I know you had some great tips for getting clients. So if you could speak to that, I think that would be really helpful. Jane, I think
yes, got it. So I think part of it really has to do with your passion for your work. If you are really excited about the work that you're doing, and for me, again, when I see somebody who's been taken advantage of, it makes me mad. I want to go charging off. And so that enthusiasm, whether for whatever field you decide to take, can be really contagious. So you want to talk to your local bar association. I started out in Baltimore County working the phones and taking calls. And then I became the go-to person for the consumer claims for those calls. So see what Baltimore County, Baltimore City, a lot of the different places will be looking for volunteers to take potential callers. Also, as I said, word of mouth. If people know that you're practicing a certain area of law, they'll come to you. For years, I was the go-to person for car fraud cases. And I really love those cases, and so subject for another day, but because of arbitration clauses, those cases became more difficult to try. And so my firm has shifted to doing less car fraud cases and more landlord-tenant cases. So we do a lot of tenants' rights issues, people who are injured in their homes or illegal lockouts or illegal charges. And once other lawyers and the friends and family who you know realize you're practicing that, the phone will start to ring. And that's exactly what's happened, especially if you're in an underserved area of law, which is what much of the areas I practice in are. As far as the internet, as Jay talked about that, I do think it's necessary in 2021 to have a presence there and probably to seek help of a professional. We broke down and hired a company to help us with our web development and internet advertising because you do now have to pay something to be seen. I think as far as TV ads, you know, we used to say that unless you're in one of the top three, you know, the three advertisers who pay millions of dollars for those ads, you're probably not going to be seen. So I'm not so sure it's worth spending a lot of money beyond having a really good website that's attractive for your area. Social media, you know, that's easy to do, just constant posting. We have a Facebook page, we have an Instagram, we do blogs on our website so that your firm is always out there. People always know that you're there and what you're doing. And again, a lot of this, you know, you could work 24/7 on this stuff. So you have to use your judgment as to how much you're going to do. But a regular web presence, social media presence is important. Volunteer for the legal clinics. In the type of work that I do, we are often at landlord-tenant court assisting. We're often at the debt collection clinics assisting, and it's not only are the organizations grateful for our help, but a lot of those people in those courtrooms have affirmative claims. So what we do is we take a case where you may be defending it, and all of a sudden the debt collector, for example, or the landlord has violated the law and coming after you. So those can be good sources of finding good cases and also helping. That is not the same as pro bono, and that's something we maybe can talk about in a few minutes. You can know ahead of time how much you want to volunteer for. And it is important to develop your practice, but young lawyers often get sucked into doing way too much pro bono, so be careful. And then teaching opportunities. Anywhere and everywhere you can get opportunities to teach is a good thing, whether it be, you know, at a senior center, at a neighborhood event. That's a free way to get your name out there, and people will be grateful for your help.
Thanks so much. Okay, so we're going to move on now to maintaining and managing your practice. So I'm going to ask Divya if you can start us off on this topic.
Do you have a specific question?
Well, so based off like this slide, for example,
Okay.
if you can take us through your thoughts.
Okay, so how do I know which cases to take? Obviously, because I do contingency work, it's important to have a good liability on the case. You have the burden of proof in my area of law, so you want to make sure that you are able to prove liability. If it is a disputed liability or not sure about it, if there are good damages, which in my case would be good injuries, broken bones, loss of consciousness, I have some wrongful death cases, that might be worth potentially fighting on the liability portion. Record keeping and documentation, that is very, very, very important. I have a case management system, Clio. I believe Jay also has Clio. And then I have an internal server where we save all of our pleadings, and the documents that our working files are saved on our server. It's extremely important for record keeping, especially for client communications. So if a client calls in asking for an update, I make sure that everyone knows to make a note of that. Whenever we have any big updates, we send clients letters and emails, call them, keep in touch with your client. You should never have clients that say, And I hear this all the time when they've gone to other lawyers, like, oh, I went a year not knowing what's going on with my case. That's the last thing you want. That's actually also another way that you can get in trouble with the bar association, with bar counsel, is not keeping your clients informed, not communicating with your clients. As far as client payment in my area, that happens at the end of the case. So when a case is resolved, we get a check, just one check with the settlement offer, or if it's a verdict. And then I deposit that check into my trust account, which is the IOLTA account. And out of that IOLTA account, we write checks to the client, to any medical providers, and then I write a check to my firm for any case expenses that I have fronted, and then the attorney's fees. Any health insurance liens, anyone else, any fee splits to other lawyers, all of that happens at the back end, at the conclusion of cases. So, and I'm sure bar counsel is going to be speaking about trust accounts a lot more, but I am so paranoid about trust accounts. I deposit a check into my trust account, and within about 48 hours, I've written all the checks out of that trust account. So I don't keep money in there for very long, but my area of practice also doesn't require that. As far as client agreements, I have a standard retainer agreement, which I modify whenever I see or hear of something new and good to add any language. I keep modifying my retainer agreements. As far as termination, there's various rules, nuanced rules for that. If there's a case where I'm not going to be able to pursue it, maybe liability is bad, maybe the damages aren't there, then I will send the client a copy of his or her filed by certified mail green card. So that way I know that they signed for it and they received it. Yeah, I think documentation and record keeping and client communication are the most important things. I think clients that know what's going on in their case, clients that have their attorney calling, letting them know updates are going to be the most satisfied clients. Obviously, the end result's important too.
Thanks, Daisy. So Jay, this next slide is yours.
Yeah.
And if you could talk to us about the back office.
Yeah. I mean, just everything Divya said. I mean, like the back office, you know, being in this position as a solo. I mean, look, at the firms, like this is stuff you don't really think about, right? I mean, you have an entire, you know, you look at the back office of some of these big firms, right? They have literally armies of accountants, folks to do all of this stuff that we're talking about. As a solo, this is all on you, right? You're the, you've got to make sure that that back office is in as best of shape as possible, because look, it's very easy. Again, I know Jess is going to talk about this, but you want to make sure that you're in a situation where if bar counsel sends you a letter, you're prepared to have everything in order. You've got your trust accounts reconciled. You've got copies of all emails and communications with clients. You've got a good calendaring system in place so you don't blow through the statute of limitations. I mean, all of this stuff has to be in place. And I mean, literally, you know, I think you got to really spend a good amount of time, get really solid in terms of your procedures and make sure all of this is in place, because if this isn't in place, your license to practice can go away very quickly, intentionally or unintentionally. It's just something that you've got to do. Don't, again, bringing in the clients, doing the work is important, but that back office has to be solid. So really spend time here, because, this is just something that you can't afford to have a mistake in. And again, mistakes happen, but you got to have those the procedures in place, the systems in place. You know, look, if you're not using a practice management software and, you're taking trust money, I mean, you're just asking for a problem. I mean, granted, if you have an accountant helping you then in QuickBooks, then okay, maybe you'll be all right. But you've really got to have this stuff in place, because your license can go away like that.
Thank you, Jay.
Yep.
So
Can I
Jane,
jump in and just talk about the importance of retainer agreements?
oh, please, Jess, thanks.
So yeah, I mean, everything that Jay just said is certainly true. And I see on this slide, he has client agreements. And, retainer fee agreements should be like your best friend. It's about risk management. Rule 1.5 of the rules of professional conduct, they only explicitly require a written fee agreement in contingency cases. But I mean, the rule states that the scope of representation, the basis or the rate of your fee has to be communicated to the client. And obviously the best way to do that is in writing. They're so important because you're not just communicating to the client what you're going to do, but you're also communicating what you're not going to do. So, if you take a case, but say it gets appealed, if you're not going to handle that appeal, that should go in your fee agreement. You don't want to put yourself in a situation where, you have a poorly worded retainer agreement, or God forbid, you don't have a written fee agreement at all, and you get in a situation where the client says, hey, I hired you for, X, Y, and Z, and you're saying, no, you only hired me for X, but you don't have any, written signed agreement saying, look, it's just X. You don't want to be in that situation. So I really want to stress the importance of putting everything in writing, but certainly what you're going to do, what the fee structure is going to be, how you're going to bill or get paid, I guess how often you're going to invoice the client is important. There's case law out there where attorneys say in the retainer agreement that they're going to provide monthly invoices, and then they don't provide invoices, and then 2 years go by and they provide this invoice for some astronomical amount and they try and get paid. And I mean, there's case law saying that that's an unreasonable fee at that point, regardless of whether you actually did the work to earn it. Your client had no idea that you were generating all of these fees because you didn't provide invoices. So I just kind of wanted to jump in and stress the importance of that.
Thanks so much, Jess. So Jane, I'm going to go to you next, but before we talk about maintaining and managing your practice, can you tell the audience if any of them are considering a partnership with a friend or colleague, some factors that they should consider?
Sure. So a partnership as opposed to a solo practice can be a really nice alternative because, you're not making all the decisions on your own. I like being in a partnership. I like knowing that there are people who are going to back me up, who I can run ideas by, who if I'm, in a low area, they might be in a high area. And I just like being with other people. But you want to be careful. My first partnership was like a Vegas wedding. My one partner had a buddy, who they used to be police officers in Ocean City back in the 70s. So, gee, let's ask him to join the partnership. And that was a disaster, So you should not base a partnership on whether the guy's a buddy of yours or, a dear friend or relative or any of that other stuff. You want to look really carefully at their work ethic, their ethics, are they honest? Are they hardworking? Does their practice fit in well with yours? What their financial situation is, because if they're in a much different financial situation than you are, if they're in financial trouble, for example, they may be they may try to take money that they may not be entitled to, or they may make decisions that aren't always in your best interest. So you have to be simpatico that way. It's probably a good idea before you form a partnership to try to do a counseling for a while, work together on cases, get to know the person before you jump in, because a partnership in every way is like a marriage, except for, I believe, the physical intimacy. Everything else, if that partner goes down, you're going down in more than one way. So that's what I would take a look at before you decide to do that jump. But with all of that said, with the right people, it can be a wonderful way to practice law.
Thank you, Jane. So Jane, I know Divya talked about, good liability, good damages. Jay talked about, back office. So I want you to talk about marinating the client, please, and how that affects your practice.
Sure. So, and forgive me for that slide. Obviously we're dealing with human beings who deserve respect and honesty and everything else. What I meant by that is that clients are, they come to you, and filing a lawsuit or wanting a lawyer to represent you is a very aggressive act. And so usually people who come, they're hurt, they're wrong, they have some sort of problem. I mean, it's a difficult profession because, nobody comes to a lawyer when everything's great. I mean, maybe adoption lawyers, or maybe if you're forming a business, if you're that kind of lawyer, great. But most of the people who I represent have either been injured or ripped off. And so they're not happy. They want blood. And your job as advocate is to fight very hard for them. I believe your job as counselor, and it took me years to figure out what they meant by advocate and counselor as a lawyer. Your job as counselor is to make sure that their expectations are reasonable and that it's clear, like people talked about before, what you can deliver and what you can't. So it's good to have the conversation from the beginning. I always ask people in our first meeting, what is it you want? And then if they say, I want $1 million and I want, that car dealership shut down, it's like, well, you're not going to get that, so you want to find out what they want. And then you want to see if they can be reasonable when you talk to them about that. Well, I really can only get you probably the money back that you paid for the car. Okay. And as the case goes along, I found that they forget things. So you have to remind them, especially in a fee shifting statute, hey, guess what? My fees are going to go up as this case continues. So you need to know that if your case is worth $20,000, but it takes me $50,000 to get you your 20, I'm entitled to the 50. People don't like that because they're used to the personal injury model where you're only going to take a portion of what they get. So if you're dealing in one of these areas of the law, you have to be very careful about that. For our personal injury clients, we advance all costs. For our consumer protection clients and many of our tenant clients, we do not, because my experience has been the clients are very, very willing for you to fight and fight and fight. And they tend to be more reasonable if they've got something to lose by moving forward. But your retainer needs to be really clear on that. And as we've talked about, having a retainer agreement that spells all that out is necessary. And we already talked about the repeated conversations and keeping the clients informed. Did you want to talk about that one?
Yes, please.
Okay. Sometimes cases go south. It happens to everybody. And I think a mistake that a lot of lawyers make is they keep trying to dig a hole after the case goes south. If you realize that your client has not told you the truth, a witness comes up who says something that completely tanks your case, you find out that the defendant who you're suing has no assets and no insurance, it's time to leave. And if you haven't filed suit, that's relatively easy to do. If you have filed suit, you're going to have to ask the court for permission to do that. But in my experience, you can't be afraid to get rid of the bad case because the money you've already put in it, you're not going to get back. And by spending more, it's a big mistake.
All right. right. Thank you, Jane. And that's basically that trust your instincts, correct?
Yeah, if every time the phone rings and it's that client, the hair on the back of your neck sticks up, and you start to get that feeling, probably not a good client to have. Now, that doesn't mean you should necessarily fire them, but that's a pretty good indication maybe you got to get out.
Okay, so I now want to turn to ups, downs, and challenges. Jane, I'm going to stick with you for a little bit to just talk about some ups and downs and pitfalls, and then we'll move on to the other speakers.
Okay, so here's the good part about owning your own practice. You get to make your own decisions. You take the clients you want. You can try what you want. You can turn down what you want. You can say and do what you want. And I'm always struck by, we work with a lot of government attorneys who are wonderful heroes, but they have to say certain things and not say certain things. And if you're the kind of person who just doesn't like being told what you can say and can't say anytime you feel like it, maybe solo practice is for you. You're not limited on income. With the other jobs, you'll get a steady paycheck, and that's very comforting sometimes when things are dry. But with your own practice, you never know what's going to come in the door, and that can be really fun and exciting. Also, you're not limited on advancement. You are the boss, so you can go as far as you want. And I really think for people to be in practice for themselves, you've got to be a risk taker. This is not for the faint at heart. So if you like risks and you think it's all very fun, then it can be a really enjoyable way to practice law. So here are the downsides. Nobody's telling you what to do, right? So, nobody's going to be over your shoulder making sure you work enough hours. We had a partner once who loved being a musician, and he would come in at 10:30 and he would leave at 2:30, and he took an hour and a half lunch. And the only time I've ever gotten sued for malpractice in my life was because of that guy. So, nobody's going to tell you to work enough hours. You're going to have your own work ethic. And if you're in a partnership, you better make sure your partner feels the same way. Nobody's going to oversee how much money you're bringing in. That's going to be up to you. So, other than maybe a spouse saying, how come we can't pay the bills this month? It's not like you've got a partner breathing down your back saying, you haven't met goal. Nobody's going to challenge your decisions. So you are at risk for making some really bad decisions, which is why mentorship is a really good idea. And there are never any guarantees of any kind, which is why I go back to rule one. You can't do this unless you like risks. And this is my slide, so I'll go over this a little bit too. Agreeing, we talked about this, young lawyers starting out in solo practice are often asked to do too much for free. Don't fall into that hole. Friends and family and strangers and everybody else will ask for favors to give you experience. Some of that is okay, but be careful. They will take advantage of you. The clients will really take advantage of you. I've seen it, I've experienced it, which again, we talked about screening and retainers, talked about the Vegas wedding partnership. And the other common pitfall, I think, is wanting to go it alone because you don't want to split a fee. And if you don't know what you're doing or you're new at this, it's much better to split a fee with an experienced lawyer. You could lose, you could undervalue your case, and especially in the consumer protection field, if you don't know what you're doing, you could make really bad law that could haunt the rest of us for years.
Thank you, Jane. Jay, I want to turn to you next. You had some good points about knowing your own value as well as exit strategy. So turning to value first, if you could address that a little bit.
Yeah, and I think it's some of what Jane mentioned. Like, you're going to be, again, as the owner of the firm, you're going to be the person looking the prospective client in the eye and making the pitch for why they should pay you. I mean, let's assume you have an hourly practice, something like that. And you've got to again, you got to make sure that when you're doing that, you again, it goes back to you having sort of confidence in yourself. You've got to believe you're worth whatever number it is you're putting out there to the prospective client, because you'll find yourself in situations where, look, prospective clients can sense when you don't feel you're worth whatever number it is you're putting out. And so you've got to make sure you value the work that you're doing appropriately. Charging low fees for work, again, if you're a skilled practitioner, obviously stay within the confines of the Maryland rules and attorney ethics, but you want to make sure you value that you're getting appropriate value for the work that you're doing. And then secondly, look, you run a law firm, not a bank. All right. Now, putting aside the contingency practice, if you have an hourly practice and you're charging clients, an hourly fee or what have you, you've got to understand that, look, again, with your client agreement, going back to what Jess and Jane and Divya said, that client agreement has to have the appropriate language in there. Again, we do evergreen retainers, where, look, we get a certain amount in trust. As we bill against that, the amount comes down and it has to be replenished. And so, you're running a law firm, not a bank. And so you want to make sure that you're not letting clients get ahead of you in terms of accounts receivable. In certain practice areas, I mean, some of these ARs can be significant. And that to me is just, it's bad management. If you're running an hourly firm and you've got a client agreement in place, you're delivering value to the client, you should get paid for that. And you need to make sure that your clients are paying you for that, because if you let that client get too far ahead of you, you're sort of like in a hostage situation. If you've got a $30,000 or $40,000 AR, you're not going to see that money. And that's, that's unfortunate, because that's time you could be working on someone else's matter. So just, again, make sure you're understanding your value, and that you're building a firm that is getting paid for the work that it's doing. Yeah. Exit strategy. All right. I know, look, I'm part of some groups that we have different firm owners that think differently about the practice of law. And one of the things that comes up is, look, when you start this firm, you need to think about how you want to exit it, right? Do you want to sell it at some point? How do you want to exit your firm? And that, to me, is something I think that gets overlooked as people start these firms, because if your objective is to sell it, there's sometimes different decision points that you'll make along the way as you're building your firm. And so thinking about your exit strategy, how you want to exit the firm, again, assuming that, you maybe want to sell it down the road, 15, 20 years, whatever number that is down the road. You need to think about that and then build your firm appropriately so that eventually one day you can sell that firm and get full value for it.
Okay, thank you, Jay. Before I turn to Divya for a couple of quick last words, I just want to thank you all for kind of hanging in there. We have one more section after this, probably one of the more popular ones that you guys are looking forward to. And after that, we will take questions. But Divya, do you have any last words on the ups and downs of solo practice?
Sure. So in addition to Jane's slides about the ups and downs, which are all very valid, some of the challenges I would also, you are wearing so many different hats. So for my brick and mortar shop, like for example, if the internet goes down, I'm the one that takes care of that. If the copier is not working, I take care of that. If any office supplies need to be ordered, I take care of that. We had a flood in the basement. I was taking care of that with the contractors. Now with the weather the way it is, I make sure that the the stairs outside and the sidewalk is being salted, like all kinds of things that my day goes off in so many different things that I have to do that does not involve practicing law, but I love it. I absolutely love it because, and here's a positive, I'm building something of my own. I come every day to this office and I love being there, and I don't mind one bit like playing maid, cleaning up after people. Not that you should expect that from your staff, but taking the trash out, those kinds of things. But when you do it for yourself and when you're passionate about what you do, there's nothing better. I absolutely love it. Although I spend so much time in my office and spend a lot of time working, it feels like it goes by so fast because I'm so passionate about it. I love what I do. I love the results that we get for our clients, and I like what I'm building. So it's all worth it. All the long days and weekends are all worth it.
Thanks, Divya. All right, so everything that the panelists have said is great. However, we know that whatever you're doing, it's got to be ethical, and you need to be following the rules. So now our last section is common ethical mistakes, and we're going to have Jess start us off, and then any of the other speakers are free to chime in on any areas that they would like.
Sure. So, my focus here is a little bit different than the other panelists. I'm not in private practice. I work for the Office of Bar Counsel. And so we've touched on a lot of these things already tonight, but the most common ethical mistake made by solos, and not just young solos, but, people who have been practicing for 40 years, is our attorney trust account issues. Their Rule 1.15 of the Rules of Professional Conduct govern safekeeping property, essentially requiring attorneys to safekeep client and third-party funds separate from the attorney's own funds. This involves, you have an operating account, that's your money. The trust account is client and third-party money, and that's just a good rule of thumb. Those two things should be separate. There's a specific section within the Maryland rules. It's Title 19, Chapter 400, that governs attorney trust account management, record keeping, record maintenance, and your requirement in opening an attorney trust account if you're in fact going to be receiving client funds, advanced funds, or third-party funds. And as part of those rules, you're required to designate your attorney trust account, IOLTA account, with the bank, and then authorize the bank to report overdraft notices to my office. So that's certainly one piece of, we get lots of overdraft notices when attorneys, overdraw on their attorney trust accounts for one reason or another. Sometimes, oftentimes it's a mistake. Hey, I wrote on the wrong check. I meant to write a check out of my operating account to Comcast or something else, but I grabbed the wrong checkbook and I wrote it out of my attorney trust account. And certainly in those cases, people make mistakes. But sometimes it's either much more nefarious than that, or even if it's not nefarious and you're not, actually misappropriating client money, we find that many solo practitioners just don't understand their obligations as it relates to the attorney trust account and where certain money needs to be kept. So I would strongly advise everybody to open up their rule books or go to Westlaw or whatever. I don't even think you have to go to Westlaw. The rules are just on the internet. You don't need a research service, but I advise everyone to read those rules because they're very specific and they are very technical, but they're incredibly important. I mean, one of the things, the most important parts of practicing law is clients entrusting attorneys with their money and their property. And when that trust is eroded for whatever reason, whether it's negligence or intentional conduct, the Court of Appeals takes that very, very seriously. And it's a easy way to either have your law license suspended or get disbarred. So, you know, you should be maintaining client ledgers, general ledgers, and those essentially should show a record of all disbursements and deposits into your attorney trust account, including the dates on which, you know, the money went in, money went out, who it was going to, the total, a check number, what it was for, what client matter it relates to. Like I said, the rules are very specific in what's required. And you need to be doing monthly reconciliations of your account down to the penny, so you can identify, you know, every penny that's in your account and who it belongs to. And the rules also provide, you know, there's some very specific prohibitions. You shouldn't be commingling your funds in with your client's funds in your trust account. I mean, certainly, I mean, I think Divya made this point. When she receives a settlement in a PI case, she's writing, you know, checks out of it immediately, which obviously there are certain circumstances where you're not doing that within 48 hours. But you need to know, you know, if you've earned the money, it should be coming out and going into a personal account or an operating account or whatever the case may be. So, I mean, I would say that is the most common ethical pitfall or ethical mistake that's made. But I'll move on to the second piece, competence, diligence, communication, which we've talked about a lot. But I will say that, you know, this is the foundation of avoiding a grievance, because oftentimes these attorney trust account issues come up because your client has complained to us about something else. And then during the investigation, we learn, oh, the money, you didn't put it in your trust account. And then that leads to other issues. But if you want to avoid talking to our office, I mean, the number one way to avoid that is to communicate with your clients, because so often the complaints we get are, I haven't heard from my attorney, you know, I've called the office, I've emailed, they haven't spoken to me. And you may very well be doing all the work, but if you're not communicating that to your client, they're going to be unhappy, and that's going to erode their trust in you. And so even if you've done this great job, you know, you've sort of already, you're, you know, working from your back foot. So, I mean, I don't want to belabor this point too much because we've talked about it a lot already tonight, but it's really important to communicate with your clients. And then one other piece I'll say on this communication, competence, diligence is, I mean, obviously we've talked a lot about how it's important to bring in enough cases and be filing enough cases or have enough cases to make a living as a solo or in a partnership or small firm. But you need to ensure that you don't have so many cases that you're unable to provide or, you know, be attentive and provide competent and diligent representation in all of those matters, because it's not uncommon to see solos who are new young attorneys who have inherited a practice from someone else, which is great. I mean, that seems like a gold mine, right? But sometimes with a brand new attorney who's inheriting a practice from someone who's been practicing for 40 years, the caseload might not be something that they can manage the same way. And it's easy to quickly get in over your head. So, and then the final thing on this slide about responding to Bar Counsel's office, under Rule 8.1 of the Rules of Professional Conduct, you know, and it requires attorneys to respond to lawful requests truthfully from my office. And, you know, I'll say up front, if you have been representing clients for your entire career, you will likely get a letter from my office. It's just, you know, it's like a rite of passage. Don't despair. It's not a big deal. The majority of complaints we received are dismissed within the screening phase. Ordinarily, we get a response, and then that response, we're able to close it. but I will say that sometimes solos or small firm attorneys, especially young attorneys, sometimes dig a hole when they respond to our office. You should, respond timely. We'll provide an extension, but if you don't respond, there's case law to say not responding to Bar Counsel's office is a reprimand, even if you've committed no misconduct in the underlying complaint.
I'm sorry, can I jump in here for a minute? Because a lot of your insurance carriers, your malpractice insurance carriers will help you respond. And if you get a complaint and you bring it to them, the policy doesn't even require a deductible. So they will help you stave off. They'll draft that letter so you don't get into a trap of saying something that you might regret later.
Yes, and I will say that my office definitely appreciates when attorneys get counsel. Oftentimes, it's easier to work with someone who's not emotionally invested. And of course, when you're getting grieved, I understand the inclination to be defensive but sometimes that's not the most valuable. That isn't the information we're looking for. So I completely agree. Check with your malpractice carrier. We appreciate working with attorneys for attorneys. And if I know we're running short on time, so if anyone wants to jump in or.
Okay, well, thank you, Jess, and everyone else. This was very informative, and I'm sure it was very helpful for all of us who are watching. We will begin questions in just a minute, but I wanted to make sure that everyone did have our speakers' contact information, and if you want to reach out to any of them with any questions that you have. So I will leave this slide on for few more seconds, and then we will start taking questions that you guys have.
Listen, it's not really a question, but while people are formulating their questions, I just want to make a couple suggestions because I have been out here for quite a while, namely 34 years in private practice, 10 years before that in state's attorneys, public defender, federal public defender, legal aid in Memphis, legal aid here in Baltimore. Young lawyers need to understand if they're going into private practice, they are the tip of the spear. They're the tip of the spear because if they have clients who have an issue with them, there's no boss to go to. They end up grieving them, going to the attorney grievance and lodging their complaints with them. And I would imagine, even though I've been made to understand that they don't keep records down there, the percentages, but probably most of the cases that end up being in front of the attorney grievance are complaints against private practitioners, because again, there's nobody else to complain to. And then there's just a natural inclination to think where there's smoke, there's fire. Why are we constantly getting these complaints about this lawyer or that lawyer, even though the complaints might be ridiculous? And so for the young lawyers, understand you're the tip of the spear. And so be cautious in that regard. Stay in your lane. Don't get into areas of the law that you really aren't comfortable with. There's no great familiarity with. Support staff. It's important to have a very capable support staff, because they're going to keep the business up when you're out moving around. And then the other thing is, you have to decide, you have to understand that you're going to be juggling a business and a profession. When I was with legal aid and federal public defender and the state's attorney's office, I was practicing law, and that's all I had to worry about. When I went into private practice on my own, now I'm juggling the running of a business and also the practice of law. And sometimes there's some conflict there. And as an individual who's coming into private practice, thinking about it, you have to understand that there's going to be conflict between the two occasionally, and be prepared to determine what is more important. The bottom line, making the money, running the business, or the practice of law, the professionalism of the practice of law. And so, those are just a couple of things from out here in the real trenches that I just felt compelled to offer up for some neophyte lawyer that is interested in coming into private practice on their own, or is already in private practice on their own, because it can be perilous out here. And I understand what bar counsel is saying, but when they keep getting complaints with your name on it, they look at you as if you are actually out here as not really running the type of practice that you should be running. And if you pull through most any lawyer, and I've listened to the mostly civil lawyers here, if you pull through their files, the attorney grievance can find some things that if it had been brought to their attention, they could ask them to respond and look for some justification. So my point is that none of us are perfect, that we all error. But when the attorney grievance kind of focuses on you, they act like that one case, that one client is the only one you have. And why didn't you call them back at midnight when they called you? And why didn't you go to the jail 5 or 6 times, even though you didn't have anything to tell them? That's the reality of it. Because again, I've been at this on my own for 34 years now. And so I know what I'm talking about, but it's to be very careful and decide most importantly, am I in this for the business, the money, or am I in it because I want to practice this area of the law? This is who I am, and let that guide you.
Thanks, Warren. Okay, so we are a little past 7:30, but we do want to get to a couple questions. So the first question in the chat was from Crystal Gaines. Crystal, if you are still here, if you want to unmute yourself and ask about the line of credit. Let me see if she's still in here. Okay, looks like Crystal might have left. So next, Leslie, was your question answered, or would you like some more information, Leslie, about the examples of good retainer agreements?
Actually, somebody provided a link that I think might be helpful.
Okay, perfect.
But yeah, thank you.
Okay, sure. Will Radowski, would you like to ask your question to the panelists?
Sure. And, I'm not sure if, this is an answer that I guess Ms. Bolts would have. It's just hearing what Jane was saying in terms of, if you need to withdraw, don't overthink it, just get out of a bad case. And I do a lot of domestic work where it's like I have a particular situation now where it's like, I really am interested in getting out. And I think there's grounds for it. I just am anticipating that kind of fallout based on the client. And am I signing up for, even if I haven't done anything wrong other than, in the client's mind, abandon them? Is there a common theme there? Is that looked at any differently when a initial complaint does come in? Do you look at that procedural posture and what's happened?
I don't know if I can answer the question as to whether the complaints coming in, if there's like a disproportionate amount of complaints that come in where the attorney has withdrawn versus other a different procedural posture. But I would say that if you don't feel that for one reason or another, you don't feel that you can achieve something for this client, or you need to get out for you should get out of the case. You certainly shouldn't remain in the case because you're afraid that the client is going to ultimately file a complaint against you. And if the court, if you're in a position where you have to file a motion for leave to be removed from the case, and that's granted by the court, that's certainly something that's going to be looked at as well by our office. So I don't know whether I really answered your question or not, but
that's okay. I did, I wanted to just put it out there. I didn't really think you'd be able to throw out percentages or anything. I appreciate it.
And Will, if I can jump in, I think one of the things that helps is to really read the ethics rules about it and to put as much in writing as you possibly can. I recently had a case where the client had just kind of gone off the rails and he just would no longer listen to me. And I came across one of the rules of ethics. It basically says, you know, if your client just won't listen to you, you know, you don't have to maintain a relationship with an unreasonable client. And I wrote like a 3-page letter detailing why I think I couldn't help him, and you know, very factual examples, things like that. And luckily the client came around, but that would have been my basis, you know, to file the motion to withdraw. And also be careful in filing the motions to withdraw. You I would never attach the letter with all the confidential information. That's a
Sure.
big no-no. But you know, you do want to say, for reasons set forth, you know, in a letter I drafted, I'm going to give the 5-day notice. I also had the court once deny a motion to withdraw with some clients who again were really unreasonable, and basically they had to sign affidavits saying that they really didn't want me as their lawyer. And although normally not something I would want to happen, in that particular case I was very grateful that they did that, because the court finally let me out, and it was the right thing for me to get out. So it happens. Just read your rules of ethics and follow the rules and you should be okay. But I think paper.
Okay, thank you.
Thank you. Thanks for the question. Well,
Mhm.
we are a little over time, but we're going to get to the last question in the chat. Joseph Gibson, if you could ask the panelists your question.
Sure, and thanks everybody, all the panelists for presenting. I really appreciate that. I'm curious, when you all struck out on your own, if you encountered any hostility to the idea of a young attorney going on their own, striking out on their own, or if people were supportive of that, because I've kind of run into both sides where I've maybe more older traditional attorneys that said, no, you go be an associate at a firm, you know, you work your way up, and then later in your career, you go strike off on your own. You don't do it when you're young. And I'm just curious about your experiences of that, and if you have any tips or pointers along the way.
Yeah, I can speak for, you know, I can say, look, everyone that I spoke to is very supportive. I think what maybe some of the older attorneys are talking about is there's a lot of training that happens at a firm, you know, assuming you're at a decent firm, okay? And that may be what their concern is, more so than apparently a hostility to you going out. It's that it can help you avoid issues later on. And so, but for the most part, everyone I spoke to when I started my firm is very supportive. I mean, I talk to my quote unquote competitors all the time, and we share ideas and what have you. So, but I think the one of the points though that I will point out is those older attorneys, there's something to working in a firm a little bit to get the experience to know how to move cases, handle cases, spot issues. It can be beneficial to start at a firm or, you know, wherever first and get some training.
Yeah, and I think that can be recreated. If you don't have that firm experience, that can be recreated by the, you know, organizations like Civil Justice, by mentoring, by, you know, by seminars, by pro bono, so that you get that type of experience without having to be in a firm. And I think some people are just old and codgy and naysayers, and I think the practice of law is really changing. You know, it's not what it used to be for, you know, the Towson, you know, seersucker suit white males. They were very popular when I started practicing, and it's not that way anymore. So sometimes people don't like change.
Okay, well, it looks like we don't have any other questions. So thank you all so much for attending, and thank you so much to our speakers today for being with us here this evening and providing so much valuable insight. So thank you guys so much.
Thank you.